Hello, everybody. I would like to pick up on the subject of restraints. And restraints of patients in psychiatric wards in Israel has been very big in the talk in the psychiatric world in the past 2 years. People are talking about it. Patients gave testimonies. There was blaming, there was naming, there was uneasiness, there was bitterness on both parts of ex-patients and of medical staff. And we have come to accomplishments over a very short period of time. There has been a substantial reduction in the rates of restraining. The question is, how do we not just talk the talk, but walk the walk? Walk towards total abolishment of this horrific practice and put it behind us as patients, as activists, as doctors, as nurses, as concerned citizens, make this something of the past. But before we walk the walk that I'm proposing, let's go back. Up until 2016, restraints has been a deep-seated practice in Israel. It occurred in all hospitals. It was very prevalent. In 2016, Bizchut, which I work for as an advocate, which is a civil rights movement organization for people with disability, together with ex-patients activists, exposed the horrific rate that restraints was being used. Contrary to belief, this was not happening only to dangerous patients in violent situations, but in a whole array of situations, from violence to verbal threats to agitation. This was happening everywhere and all the time. People were restrained in 4 limbs, on designated beds, in secluded rooms for hours and for days. And what we exposed was the rate of the phenomenon. 1 out of 4 patients in hospitals had undergone restraint, and in the acute departments, we're talking about 1 out of 3. So this was happening everywhere. Following the exposure and very fierce media coverage, the Ministry of Health and the psychiatric community acknowledged the facts, acknowledged the numbers, and propelled a very dramatic and systematic change. And the numbers have gone down dramatically in a very, very short period of time. In 2 years, as you heard before, there was about a 60% reduction in the numbers of restraint. So I could make my talk very short. I could make it about the strength of civil society and of engaged psychiatrists to make a systematic change. But as a lawyer who is activist in this area, I won't. I won't break the record of a short talk in this conference, because we're looking at the aim should be a sustainable, long-lasting, systematic change aimed at, in my opinion, at abolishing totally the use of restraints in psychiatric hospitals in Israel. However, this is not as easy as it sounds. Restraints have been used all over the world. I'll speak about it more. And countries all over the world have engaged far earlier the endeavor to cut down, to reduce restraints. However, it is still authorized by law in all countries. In European countries, in the US, which has been struggling for 30 years to abolish restraints, and even in one state in Pennsylvania, over a 30 years endeavor has been able to reduce the numbers in 99%. However, the law still allows psychiatrists discretion when to use restraints. Not only is it legally permissible, it turns out that the courts all over the world do not intervene in the use of restraints. In Israel, there is no case law. In Europe, only very few case laws in the European high courts in very easy cases. And in the US, the constitutional law has not been used effectively in courts. So courts do not intervene and view this as a professional matter at professional discretion. Now, this is puzzling considering the gravity of the practice, of its consequences. And it's puzzling not only from a legal point of view, but also from a medical point of view. There is multitudes of research, medical psychiatric research, as to the outcomes of restraint. There are no positive documented results from restraint, and there are multitudes of dire consequences, including death, from this practice. However, we see that the medical community, although succumbing itself to measures how to reduce the use of it, has still, if you will, kept this tool in the garage. It's still part of the array of tools that could be used. Psychiatry itself has not gotten rid of it. So it's still in use from a medical perspective, and the court and the law do not intervene. And after months of advocacy and discussions that I've been engaged with in the past 3 years, I've come to a conclusion that although I'm debating with psychiatrists, the arguments I'm hearing are not medical arguments. They're more of common sense, practical arguments. How do we deal with these people? How do we deal with the problem? And my conclusion, or my assumption, was that this is in fact a social and moral conception, decision. And in order to tackle the problem and achieve total abolishment of the practice, we have to dig deeper into the bedrock of restraint practice. And this is what my research has taken me to. So what did I find? Let's start with the easy. Restraints have been used in psychiatric hospitals for years. It's well documented. From the 19th century, it's been in use. But restraint is not an ordinary medical practice. Meds have changed. Medical practices and procedures have changed over the years. Restraint has basically stayed the same. It looks the same. It is practiced the same. It is the same. What is less known is that the use of restraint, this deep-seated common practice, has been in place long before psychiatry. The practice has preceded psychiatry. Asylums were notoriously famous for using restraints. And what I found was not only anecdotal pictures of people being restrained, but what I found is a pattern of the usage of restraints. Whereas every single phase in time in history, starting from the 16th century in England, the group or the individuals who were designated the caretakers of people with mental disabilities were also given the authority to restrain them, to tie them. And when the authority was given to another group of professionals, the authority transferred to their hands. So there is anecdotal documents about restraints used by Roman doctors. But my research went back to about 500 years in England. And I want to map out the phases that I found of the usage, the organized use of restraints during this time. Okay, the first phase was that the care of people with mental disabilities was a private affair. The state did not intervene. It was the responsibility of the family, of the community, and this was handled in the private sphere. The state did not intervene. But it was considered morally acceptable and socially acceptable that if you are a family member taking care of your next of kin, you are allowed to restrain, to tie up him or her. So this was the first phase. The second phase is the state taking responsibility over people with mental disabilities, understanding that it's part of the state's duty. And this is the era of asylums. Big institutions set up, first in England, later in the UK, and later in America. And the asylum era put in regulations about the use of restraints, trying to curb the discretion. But what happened was that there was a lot of abuse of powers. But what is interesting is that the responsibility shifted from the family members to asylum managers. Private people could not restrain family members anymore. Asylum managers could. They were given the responsibility. The third phase is the non-restraint movement. This was a reaction to the abuse of the power to restrain within the asylums. And the people who upheld the flag were the pioneer psychiatrists. Their raison d'etre for being this new field of medicine was to fight the use of restraint, was to abolish this horrific, barbaric act. In their views, we're talking in the middle of the 19th century. So for 40 years in England, there was no usage of mechanical restraint. This was a moral, this was a medical take, and this was the position that they held. However, this was short-lived. The patients remained the same patients, difficulties were the same difficulties, and restraint was put back in fashion, but now it was transferred from the asylum managers, which who no longer had the authority to restrain, to psychiatrists. We are doctors, we can do this responsibility, we can do it medically, we can do it under discretion. And I thought, okay, if this is the pattern that I found, that the responsibility shifts to whoever is the new take carer, I'll find it the same pattern in Israel, if I'm right. And I was. In Israel, we can see, although there are mass differences at that time between England and Ottoman Israel, the same pattern we see. First, it was the private sphere. Then it was given, there were no asylums here. There wasn't before psychiatry. And soon enough, the psychiatrists were giving sole discretion to restrain people, and family members could no longer take this action. But what I also found is that the law not only authorized the caretaker to restrain, it played a much greater part in this social phenomenon. It is an actor, it is a facilitator, it makes restraints morally, socially acceptable. And the law has been an actor ever since the 16th century. The common law in England, as I said, allowed at that time the caretakers, the family members, to restrain. What does that mean? If you tie up people, you could be criminally charged. It's a criminal offense in other circumstances. It could entail damages. So the law is needed to shield the caretaker and allow him or her to restrain. And it identifies who can do it. But I claim, using critical legal theory, that the law does more than that. The law not only reflects social attitudes, it builds social attitudes. It generates negative attitudes towards people with mental disabilities. It puts them aside, it degrades them, and it impels further use of restraint. All over these hundreds of years. And in Israel, we heard psychiatrists telling us, what do you want? We are following the law, we're not criminals. So what is the point of this? Restraints, from my research, is neither a response to perceived danger. It is not a medical intervention. It is accepted mode of handling people with mental disabilities and handling madness. the conclusion is that these people are subjected to an entirely different set of norms because of their disability. Where does this lead? I talked about the problems of the law in helping this practice totally eradicate from the world. I'm proposing another path that could be taken, which goes back to if we understand the roots of the phenomenon, we can delve another solution. International law, the UN, the United Nations, CRPD, the Convention for the Rights of the People with Disabilities, totally bans practices against people with disabilities if these practices are based on social notions about people with disabilities, if it discriminates them, if it reflects negative attitudes, and if these actions abuse the person, the liberty, the security, if it exposes them to inhumane treatment, then it is totally banned if it is based on social attitudes towards people with disabilities. And this is what I saw in this research, which means that, and I'll sum up, that understanding that restraint is a social phenomenon. If we go back to the roots, to the bedrock, we are able to see it from the outside. It was easier for me when I didn't know all of this, when I can blame psychiatrists for losing sight of patients, of morality. But it turns out that the psychiatrists are only the current players, the agents. It's been centuries of this practice, and the law is no less guilty. I think that this understanding maybe can give us a path to hope. If it's not a medical truth, if it's a social construct, we can try to tackle it through social channels. Thank you.